Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring, with a background that includes both legal work and hands-on business roles. I'm Lisa Mosby, and today we're talking about negotiating business purchase agreements and what really drives the outcome of a deal once the parties move past the letter of intent stage. Welcome back, Mark. Thank you so much for joining me and sharing your expertise today.
Great seeing you, Lisa.
Mark, once a deal moves past that letter of intent, what role does the purchase agreement play in defining how the transaction will actually work?
Yeah, so I think it's important to understand that a lot of small business deals, and I mean, quite frankly, even I've done tens of millions of dollars of deals where a private equity group is acquiring a relatively large business, and I'd call it lower middle market beyond a small business. And a lot of times, the letter of intent controls throughout the entire process of getting to a closing. And you're negotiating the asset purchase agreement and, on a lesser extent, a stock purchase agreement or membership interest purchase agreement. And you're negotiating that all the way up to a closing, and the final document gets signed along with a host of other title transfers and things like that at closing. Gets signed, the asset purchase agreement, and we'll call it an APA, gets signed for at the closing. And you've been operating kind of naked without that document in place on more than half the deals that I do. So the document itself and the negotiation during this period is you're getting an expectation on where you're going to end up, but it may not be binding unless within your letter of intent or a side agreement on creating some kind of risk for the buyer to maybe have an earnest money that goes hard after 30 days or 60 days, even if you haven't gotten to a final document, and have an escrow agreement associated with that with some, kind of return of capital contingencies if it's something related to financing or something like that. So long story short, the LOI gets negotiated over, depending on how quickly, weeks, or, can be super quick if everybody's in line. But ultimately, when you get to the letter of intent stage and maybe a whole lockup or no shop provision or exclusivity provision, then you're locked up for a period of time as a seller, and you're going to be trying to negotiate and get to a closing as quickly as possible because time is not friendly to any deal. And so you want to try to push forward, and you're simultaneously negotiating the key deal documents and providing due diligence to the buyer through that entire period.
And then at a high level, what are the main sections of a purchase agreement that tend to have the biggest impact on a deal?
Yeah, I mean, so everybody arrives at a purchase price of some kind. That's easy, as far as just the naked number of X for the X for the defined assets of Y, and that's the easy part. It's a question of timing. There's an old saying, and I think I mentioned this on our last podcast. You tell me the price, I'll give you the terms, and that is a pretty common mentality of people where it's like, hey, look, $1 million today is the old bird in the hand is worth 2 in the bush kind of thing. So if you get it, cash up front with no contingencies, no holdbacks, which is like, maybe a couple $100,000 gets held back on $1 million purchase price for some performance benchmark of the business post closing. So price, designation of what you're buying, and the timing of that is the simple part. Then it's all of these variables that come into the purchase price: holdback, earnout, which is just another term that we may get into with respect to purchase price, and these are all post-closing performance items generally. And so then it becomes like heavily negotiated, or also what are called representations and warranties, and that's the seller representing that what they've provided is accurate. And there's a whole series of this. This is not simple. And then there's a consequence or a warranty associated with if it's not. And that can be fraud. or it can just be a capped, what's called a basket associated with indemnity and or holdback or purchase price adjustment consequences, depending on what happens with regard to a representation and warranty, and whether it's some de minimis thing or something small versus something highly material, then it may change what kind of financial consequence there might be, or God forbid, an attempt by the buyer to declare fraud and rescission and try to put the business back to the seller, which may not be possible. It's hard to put the genie back in the bottle, and you can run into serious problems associated with that. And litigation is just the worst thing for the operation of any business. So you want to avoid it at all costs, and that's why you want lawyers involved that are going to end up identifying these issues, negotiating them, and hopefully minimizing the chance you're ever going to have to deal with it because the deal is fully baked.
I want to unpack some of those things that you mentioned just for clarification purposes. Representations and warranties, they're a major part of the purchase agreement, but what purpose do they serve and how do they affect risk between the buyer and the seller?
So I think the best way it's an insurance policy for the buyer, in the sense that the buyer is coming in with, it's an asymmetric information problem, all right? So the buyer's coming in and doesn't know a whole heck of a lot about the business. They may be a very experienced business person, and there may be, they're rolling up very similar businesses, so they understand what to look for. But they need to get disclosure schedules or disclosures from the seller and clean, good information that they can use to conduct due diligence and underwrite, which is more of the financial analysis of obtaining or acquiring a business. So the buyer wants the seller to be, swearing this is accurate. This information is good, clean. There isn't anything being hidden. There is no litigation. We have the authority to sell, and most critically, that the past revenue is clean, clear, accurate, and the expenses associated with running this business is clean, clear, accurate, and there's a limitation to the and given that there's a limitation to a problem in the future as long as the business continues to operate in the same kind of continuity. Now, granted, new buyer comes in, they can screw it up. COVID could hit, screw up any business. There's risks outside the four corners of the deal. But the more you can get the seller to provide clean, clear information and represent and then warrant it with a consequence in the event that it's not accurate, that is what the buyer is looking for. So the buyer negotiates hard to have very broad terms on this, and the seller wants narrow terms so that they are not just saying, into perpetuity, I am responsible for any bad thing that ever happens to you. That is the worst term for a seller and the big great term for a buyer. But that's why you try to narrow it down to something that's reasonable and an industry standard. And deals can fall apart on those things, but generally they don't. It's more of the economics and the quality of the assets that are being bought. It may be determined that, hey, look, I'm buying 50 contracts at 50 different locations, and these are all the revenue streams for a business. And if it turns out one of those contracts is 50% of the revenue of the business, and it only has 3 months of term left, well, that would be a very important thing to try to discover early on, so that you can then maybe put an earnout provision or a revenue guarantee provision, because if that one contract falls apart, the business may be worth half of what it is or less, depending on whether you can adjust your expense ratio on that. So those are all the things you got to worry about within that. And the buyer is very concerned about, hey, am I getting what I'm paying for?
Another area that I want to clarify or clean up a little bit is the indemnification provisions. They often become a key negotiation point. How do those provisions work? And what should each side understand about how risk is allocated after the closing?
Yeah, so I'll get into just generally what they are first, and then how they may differentiate between different deal structures. So indemnification basically just means that somebody else is going to take responsibility for bad things happening to you. Now, the seller's indemnifications are usually more important than the buyer's. That said, if the buyer takes on a liability such as a commercial lease in buying a business, that seller may not get off of that commercial lease. The landlord will say, hey, well, I'll let you transfer it to this new company, but you're going to be you're going to remain on the hook, Mr. Seller, after the closing in the event that the person you just sold to defaults on my lease. Well, okay. So then the seller says, all right, Mr. Buyer, if you screw up and go bankrupt or default on this lease, and then the landlord comes after me under a personal guarantee, most likely, I'm coming back after you. And then the question is if the person's bankrupt or the business is bankrupt, what are you going to get? But it's a matter of putting some teeth to it. So that is one kind of an indemnification. But the indemnification can also be, if it's a single member LLC or a small business, which is primarily who I represent now. When let's say it's an LLC, so there's 3 members. Those members may be, they will, if they sell the business for $1 million, then they get the cash. That cash gets distributed to each one of those 3 members. And if there is an earnout or there is some kind of a potential clawback beyond any holdback. So a holdback would be you sell the business for $1 million, $2 million or $200,000 is held in escrow, or maybe not in escrow, but just buyer's obligated to pay it later. And if there's some performance problem, then that $200,000 doesn't come. But there can be consequences beyond that $200,000, and the seller could actually be liable for more than that. And then where are you going to get it from? You're not going to get it from the business that just hollowed itself out and sold all its assets. You're going to go to the 3 individuals that are involved, and they would have some indemnification obligation to be subject to a lawsuit if they don't pony up the money that they are liable for or found liable for in the event of litigation. So basically, indemnification is essentially, I'm going to insure your risk. And then, so when that happens, you got to pay attention to it, because it may be 1% chance, but the last thing you want is when you think you're sailing off into the sunset is to have somebody coming back after you as a seller. So
I'm tracking with you. Payment structure is another area that you've referenced a number of times with earnouts and holdbacks or deferred payments. How do these structures affect what each side is actually taking on after the closing?
Right. Yeah, I think it's good to give an example in these instances, and I just use these a round number of $1 million because it makes the math easier. But I think you asked about holdbacks and earnouts, but if not, we'll talk about them kind of in conjunction with each other. So again, if you have a purchase price of $1 million, and then there is, back to the representations and warranties argument and the indemnification and everything, there's risk post-closing. There's risk of, was good information passed, or just some exogenous risk, such as COVID, or, which is a huge one, but, there are other smaller local exogenous risks that just can impact the business. I mean, the economy can go down. A plant that is associated with, you look at the old, kind of Rust Belt towns. I mean, a plant shuts down, it has consequences cascading throughout the entire community. So, and it can impact the business, especially if you're a supplier to that plant. So, but the holdback is again, the $200,000 example. Pay $1 million for a business, but only $800,000 in cash goes into it. $200,000 is held back. All right. What are the conditions to get that holdback money released? Well, it may be an earnout where the seller remains on the job as a consultant or employee of the company, and during that time may have a salary or some consultation service fee, but based upon the performance of the business after the closing, then the seller will get the balance of the holdback. So the holdback is the mechanism, and then the earnout would be what is the performance benchmark in order to get to that release of those funds on the holdback. And that's an oversimplification. I mean, there's a lot of conditions that can go into it that aren't just necessarily, the seller working for the buyer. But that's a typical one. Others could be just a revenue benchmark, a renewal of a large contract, which I mentioned earlier in this podcast, where if you have one key critical, be it supplier or customer or whatever it is, and if you got them under contract, but the contract's about to expire, it is not as valuable as a contract with 10 years of remaining term with a high credit customer, right? So it's about the quality of what you're buying, quality of earnings, quality of future earnings. That's what the buyer is buying.
We've talked a lot about what's included in the purchase agreement with the purchase price and if things go well. Let's talk about the responsibility after closing, especially if something doesn't go as expected. How is that referenced in the purchase agreement?
And it goes back to the representations and warranties. I mean, so
Okay.
the representations and warranties are the verbiage, and then they're tied into what are called disclosure schedules. If the deal is relatively complex, and I'm not, even simple deals should have some level of disclosure schedules, even just an asset list of what are you selling, but then disclosure schedules related to litigation, et cetera. So the seller is representing and warranting certain things. Then they are providing the information through documents, tax returns, financial statements, possibly an audit. In this instance where you're buying a bunch of business relationships, the contracts associated with that, going back to that 50% guy or 50% customer. But usually, hopefully, your contracts are, each one is, you have 100 contracts and each one is 1% of your revenue. That is way less risky than one contract being 50% of your revenue. So all this stuff goes in to these disclosure schedules and an electronic deal room to where this information is flowing to the buyer. And then to the extent that there is something hanging out there in the wind that you represented, either existed or didn't exist, such as there's no lawsuits, then it doesn't exist. Or, hey, these series of contracts do exist. So you're making that representation warranty, you're providing the disclosure, you're providing them the documentation or the lack thereof. And then the consequence post-closing is, what if it's not accurate? And what if it materially negatively impacts the business? Get ready to get sued, because the buyer is expecting you to be honest. The buyer is expecting you to provide reasonable inquiry at a minimum. A lot of buyers try to say that basically this never happened. And I always, if I'm representing the seller, I'm like, hey, upon reasonable inquiry of the seller, this never happened. But I'm not going to ever give absolutes, because what if they don't know? I mean, I have clients that don't even know they've been sued because they've never been served with process. And so they're ignorant to it until the sheriff shows up and gives them a lawsuit. So how can they assert that they've never been sued? They can't. If they're smart, they wouldn't do it. So all these things come back to, hey, if somebody pays $1 million for the business, and then there's a $500,000 consequence, but there's only a $200,000 holdback, you're very likely to get yourself into a lawsuit as a seller when the buyer is like saying, hey, wait a minute. And this is if it's clear that there was fraud or misrepresentation or recklessness on the disclosures. But the old saying of possession's 9/10 of the law. If there's $200,000 in holdback sitting there that the seller hasn't, or pardon me, the buyer hasn't paid yet, it's easy for them to say, "Come get it. You've committed a bad act. I'm not paying you, and you're going to have to sue me to get that money." Well, what if the damages to the buyer exceed that $200,000? And they got to make the decision on whether they're going to sue for more than that $200,000. And both sides could sue each other, trying to claim the high integrity and honesty as a seller, and the buyer claiming that they were scumbags or just reckless in their disclosures. So you want to avoid all that, because you're trying to operate a business and make money. And so, hopefully you've done a good job as a lawyer representing your side, to where there's as little risk as possible for either party that you're representing.
There are so many pieces to a purchase agreement that we often lose sight of some of those things as business owners because we don't have that legal background. So I want to thank you for your time today and your expertise in breaking this down and creating some clarity around it. If folks want to have a conversation with you about this process, where do they start?
I mean, I always recommend that I am not your personal Google. All right. I get inquiries from people and they want me to lay out everything about how to do a deal. Go to my website. And this podcast will be on there. It'll help inform you. There's many other podcasts on there. And just going in and getting yourself educated on the business sale process, either through your broker or which, can be good or bad, depending on the quality of the broker. But the more educated you get on the front end, the more efficient you're going to be, and you're going to be able to ask the right questions of whatever lawyer that you're looking for. But you definitely want somebody with experience. You definitely want somebody that with some business acumen. There's a lot of lawyers that, as I said, try to play both sides against the middle, and they're not doing it, kind of nefariously. It's just they're trying to offer kind of a prepackaged service. And, look, prepackaged is good if you're buying something off a grocery store shelf, but prepackaged is almost always a disaster if you are trying to truly protect yourself against your specific situation. And, got to spend money to do it. And if you're going to be buying or selling a business for, $1 million, you do need to be prepared to spend some money in order to affect that.
Well said. And I think that's where we'll leave it today. Thank you so much for your insights, Mark. We appreciate it.
Thank you.
Folks, that's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you're negotiating the purchase or sale of a business and want guidance on structuring your agreement, you can visit battlesonlaw.com to connect with Mark. Thank you so much for listening, and be sure to like, review, and subscribe to the show. We'll see you next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.